Welcome everyone. It's your immigration attorney again, Anthony Ray. The L-1 visa category is an excellent way to temporarily transfer your key employees to the United States. However, in recent years, the USCIS has gradually tightened eligibility requirements for the L-1A classification. This tightening is most clearly seen first when filing an L-1A petition for a newly established company, and second, when the position does not meet the USCIS managerial or executive requirements. Employees who qualify for the L-1 visa category are those employees possessing specialized knowledge, are managers or executives who have worked for at least 1 year in the past 3 years for the foreign company and are being transferred to the related U.S. company to work in a managerial or executive position. L-1A visas are limited to 7 years. Family members are granted L-2 status. Also, L-2 spouses can apply for a work permit. Managerial positions include the following characteristics. The person manages the company's department, subdivision, function of, or a component of the company. Supervises and controls the work of other supervisors, professionals, or managerial employees, or manages an essential function within the company, has the authority to hire and fire, and exercises discretion over the day-to-day operations of the activity or the function. Executive positions include the following characteristics. The person directs the management of the company or a major component or function, establishes the goals and policies of the company, exercises wide latitude in unrestricted decision-making, and receives only general supervision or direction from higher-level executives or the board of directors. Newly established companies are great targets for the USCIS. While it is easy to set up a company in the United States, meeting the written, unwritten, and sometimes made-up requirements are more challenging and complicated than you may think. Newly established businesses need to have a business plan with 1, 3, and 5-year goals. The business must be properly and adequately funded to assure that the business gets off the ground. The business needs to have employees. The more employees, the better. The business must document everything from small ticket items to major contracts with clients. Additionally, it helps to have an accountant to help set up the company to provide tax advice and key financial documents. Newly established businesses are granted L-1A status for an initial 1-year period so the USCIS can check on the company's progress. The business does not need to turn a profit in the first year, but it must make progress in growing the business and have the financial wherewithal to continue operations. One of the major problems for L-1A petitions is showing that the position is truly managerial or executive in nature. Businesses with few employees or job duties that do not resemble anything managerial or executive in nature are the common reasons for the USCIS to issue requests for evidence, RFEs. A company that opens a sales office in the United States but only wants to hire 1 or 2 employees will find it very difficult to show that the applicant is an executive or a manager under the USCIS's definition. Whether right or wrong, the USCIS will often determine that the L-1A applicant will be compelled to undertake non-managerial or non-executive duties in the business where there are few employees. This is detrimental to a case. Additionally, small and medium companies often do not spend the necessary time or resources to draft and prepare detailed job descriptions, which include qualification requirements. For example, in some companies, a general manager will handle both managerial and non-managerial duties. This is problematic when applying under the L-1A visa category. Careful review, discussion, and drafting of the job duties are critical for a successful L-1A petition. So, what are your thoughts on the L-1A visa category? Has your business experienced an L-1A denial for one of the reasons stated above? How did you overcome that problem? Now, more than ever, it is important that you have an immigration attorney involved in your immigration case to navigate the ever-changing immigration landscape. Get the Ray Law Advantage. Get the information and knowledge you need to have peace of mind. Until next time, stay on the right immigration path.